can ask your questions. If there's an issue with my voice, let me know. Let me see. Okay. Okay. I have about 20 to 25 minutes for this live. Anyone joining live can ask their questions. To begin with, I will start some updates that I have. So, as I think the latest in the news is about the care workers. Any care homes that they want to hire someone, a care worker, internationally should hire someone from the UK first. That's what the Home Office and the UK government has decided. So that is kind of a good news for anyone in who is on the care worker visa and whose sponsor has lost the license or their employer is not giving them work. I had made that previous shot where I have given the link, where I have given you the link to the document for DHSC, Department of Health and Social Care, Social Services. You can download that document. Anyone who is in need, who is in a care work visa, but the employer is not giving them hours of work, usually that contact of DHSC and the document is mainly for individuals whose sponsor has lost their license and they have a care worker visa. So that is the first preference. And also others who are being abused. Basically, they have a care worker visa, but the employer is not giving them the work, whether full work, half work, or no work, whatever that is. So those are the individuals. You can watch that short. It is on the channel maybe a week before I had made it. So that is good news from Home Office that all the care workers who are already in the UK should be considered first to give any jobs, and that has to be justified. So anytime a care home applies for a defined certificate of sponsorship for anyone to be employed from overseas, if they're trying to bring someone, they will have to justify and show proof that they tried. It will be impossible for care homes to do that. Many there are many individuals who are on care worker visas, but the sponsor has lost the license. So it is a very common occurrence. So I think care homes will not be able to hire someone from outside the UK for a considerable period of time. There are thousands of people who are in this situation, whose sponsors have lost their license, and that they are in this situation. So I see so live question. Let me take that one. So it is, we got a latest update for skilled worker. I'm trying to find out way to figure out minimum salary requirement for production engineer for extension. There is no update for the skilled workers. The latest changes that happened were last year, April 2024, and those are the only changes. For extension, yeah, you need to look at the job codes, etc., and see the if you join the so just to help you out, if you join the skilled worker area before that change happened in April last year, then the minimum at that time when you applied would have been 26,200 subject to your jobs minimum, and now it has increased to 29,000. So that is the lowest that you can be paid, or whatever your job code requires, whichever is higher. Hi Ryan. Anyone coming live can ask their questions. I'll be live for about 12:25 or 15 minutes or so, 15-20 minutes. Do you know this? A new member has joined. Thank you very much for becoming a paid member and supporting this channel. Do you know this? That is your name, I think. Welcome to Home Office Insider. Yes, there are channel memberships. Anyone interested can go in the channel information and you can see them, where I think there are perks listed over there. This live I'm trying to use it to give any answers that anyone may have. Okay, so the first update that I said was about the care worker. So to summarize, Anyone who is on a care worker visa in the UK, their sponsor has lost the license, they will be prioritized. They have to be prioritized by any care home. There is no option. Any DCOS applications that will be made by any care home or for a care worker visa by anyone, uh, home office will ask them evidence to show as to why they are not hiring someone who is already in the UK, has a care worker visa, and they're not giving them this job. It will be very difficult. So that is quite summarily. Uh, care workers coming from outside UK will stop for a long period of time. There are many care workers who are inside the UK, their sponsor has lost license or they are not giving them hours, etc. So yes, good news for the care workers who are already in the UK, and bad news for someone who was trying to come to the UK on a care worker visa. So that is the summary. So a second part is about EU settlement scheme. Yeah, whatever updates I've got in the last 1 or 2 weeks, I'll try and give them. Automatic extension, automatic upgrade from pre-settled status to settled status has been started by Home Office. It has been confirmed. But remember, Home Office advertises this automatic upgrade quite heavily. But majority cohort of people who are on pre-settled status as of today will not qualify in that. So the only way they are going to upgrade to settled status is with two records that they have. One of them is if they have NI number records for 5 years. If you pay taxes, whether you are salaried, self-employed, whatever that is, they see your tax information for a continuous period of 5 years, and you are a European citizen. These are the two combinations. One option. Second, you have benefit records, whatever you receive benefits over a period of 5 years, whatever those benefits are. So public funds, uh, so government funds, if you received and they have a record, DWP, Department of Works and Pensions, has a record of 5 years that you received. That's how Home Office will check from the DWP records anyone who has received it for continuously for 5 years, number one, and that person is a EU national. Okay, that is the only cohort that will be upgraded from pre-settled status to settled status. Anyone else on the pre-settled status, that is almost 80%. So in the cohort which will be upgraded, that is just 20% or so. 80% of the people who are on pre-settled status are family members in some way, either unmarried partners, spouses, children, dependents, etc., etc. They will not be upgraded. They have to do the normal applications and apply for upgrades whenever they are eligible. So I know Home Office does advertise all these things quite heavily, just because of whatever political situation that is. But then in reality, it's a very small cohort that will be auto upgraded. Uh, okay, hi Ryan. Abdul Rahman, my EU settlement application is pending. I have an e-visa, but I can only be accessed. It can only be accessed through my expired BRP. However, I cannot add my passport details, so I'm traveling. It will be a problem. If you are entering the UK with an expired BRP card, which expired on 31st December 2024, and if you come back to the UK before 1st of June, on or before 1st of June 2025, you should be fine. Just carry that expired BRP, and the carrier should allow you to board the flight. You can watch the latest video that I have made about BRPs expired, whatever that title is, expired or valid. So you can watch that, where I have explained in detail about the concession. So if you are entering the UK back on or before 1st of June 2025, you should be fine using that expired BRP card. You don't need to update your passport. Okay, what else? The next update, yes, on the EU settlement scheme only. So Home Office has also slowly begun curtailment of pre-settled statuses, especially of family members, especially unmarried partners, mainly unmarried partners of EU nationals, and also spouses of EU nationals, where they have information. So there are steps. I think I've explained those steps in another video. uh, Let me just answer this live. KT22, if I have received my first cost before 4th April 2024, how can I check the salary requirement as the job code is changed for now for extension? Do I need to consider old job code table or the new one? You'll have to consider the new table and see. So let's say your old job code was 1234. In the new job code, you need to match that. You have to match the job description. See, I know they have split, they have changed the numbers also of many job codes. Let's say you had 1234 as the job code. In this one, you have 4567. So you will have to give the salary of 4567. Look at the lower threshold. Lower threshold would apply to you because not the higher threshold. and lower threshold or 29,000, whichever is higher summarily. But yeah, for exact calculations, usually I would advise book a paid consultation with us. The link should be in the description of this video and all, where we can calculate exactly for with your situation. I tried to update my passport details on my e-visa, but I am receiving the message that until my application is pending, I cannot add the new document. Yes, that is correct. That is correct. You won't be any app if the application is pending, it won't allow you to change the document that you use to access the e-visa. So that is it. And what was I telling about pre-settled status? Yes, pre-settled status curtailments. So in the Home Office internally, there is a team that sits, that is called as status review team, that sits in between Home Office, where also relationship breakdowns go over there. For example, if you have a spouse visa and the sponsor has reported relationship breakdown, not living together, you are broken up, living separately, or divorce, or whatever that is, relationship breakdown is reported, it goes to the status review team. They look at all the information that they have from previous applications, and from that they take action. In case of a spouse visa where a British citizen has sponsored someone or a settled person has sponsored, under the British immigration rules, with that whatever financial requirement, 18,600 or 29,000, whatever applies to you, in that case the status review would usually curtail the applicant's leave, cancel the applicant's leave. The curtailment word has been gone from the system. So yes, that is what will happen. So what that team is doing for pre-settled status holders, where they have come to know of relationship breakdown, usually they would come to know where someone has reported, let's say the partner has reported the sponsor that I'm no longer with this person. Especially for unmarried partners, they would lose their right to live in the UK. So this is also a warning to unmarried partners of EU nationals who have pre-settled status on the basis of their durable relationship with their partner. You don't have a right to, I think I had covered this in some other video, just to summarize, if you don't have a right to live in the UK if your relationship breaks down, and there is no retained rights option. So you don't retain rights as a spouse would do. If you were married for minimum 3 years, of that minimum 1 year you have lived in the UK. So that is the requirement for spouses. Yes, they have the retention of rights option, but for unmarried partners, within the 5 years of living in the UK, you, if your relationship breaks down, yeah, so you should be on the pre-settled status for minimum 5 years, and if your relationship breaks down, that's the end of it. You don't have any right to on that basis. No retention, no no USS right. You have to consider other options, whatever they are under the immigration rules, skilled worker visa, student visa, whatever that is. So that is the summary, and Home Office has started cancelling the pre-settled statuses of, especially of unmarried partners. I know many people have contacted. I have done consultations also on that, where unmarried partners pre-settled status has been cancelled because their relationship has broken down. And also spouses who are married, if Home Office is aware that the marriage, if you are not meeting the retained rights requirement, which is minimum 3 years of marriage, and out of that minimum 1 year of living in the UK, if that is not met, Home Office would cancel the spouses. Even if you're married to a new national, they would cancel the pre-settled status, and because the spouse will not have any retained rights, they are checking against the retained rights rules and they are cancelling them. So that has started. That is a recent one where they have confirmed, yes, we have started cancelling pre-settled statuses. Others will also come. I know that Home Office has also confirmed that they will slowly start taking the data from the borders of entry and exit for EU nationals, and that will come towards the end of the year. I know they are working on the system, how to make it perfect, and then they would start cancelling the pre-settled statuses. Anytime they cancel the status of pre-settled status holders, they give them one option. I know that is as a courtesy to show minded to cancel. Minded to curtail was the term before. Now they write down in the letter, we are minded to cancel your pre-settled status. Please give us in evidence that why we should not cancel your status. So they give that option. But as soon as that comes, speak to an immigration lawyer. You can book a consultation with me, can discuss, and I advise on these matters. But that is the new thing that has started. So care workers in the UK, good news. And pre-settle status, EU settle automatic extension. I'll take the live questions. I know they are coming, but I just wanted to cover the updates. I think I have some more, but let me answer some live questions. What are they? Okay, okay, KT22, thanks. Patty applied for 23 years long residence over 4 months ago, and nothing has been said. Any advice, sir? Um, have you done it through a lawyer or someone? Minimum 6 months it would take. I remember I've done several of them, even last year, and whatever are in the process. We do many of these. The 20 years long residence, not 23. You may be 23 in the UK. That's fine. Uh, it will take minimum 6 months. Usually it would go up to 12 months or so. But the recent ones that we have received, about 7 months or so. So yeah, you may not hear anything back. 4 months. 4 months is too short. The queue is quite long for that 20 years long residence. Bharat Pant, I'm interested to know whether a student receiving a bursary from Department of Education will be considered a if government funded student or not. That's a very technicality. Let me see. I'm interested to know whether a student from the Department of Education bursary from the, so you are receiving uh, government fund. I don't think so, because the government funded, if you are looking at the graduate route or any rules for the skilled worker visa, or in the rules I know there is a line, if your studies were funded by a government, like they mean another country's government, not the UK government, I'm pretty sure. But to the best of my reading, yeah, of the rules, I don't think if a UK department has sponsored you, I don't think so. But then check with them. I would say it's always better to check with your the department whichever has sponsored you, given you the bursary, that they are happy for you to apply for the next visa, whichever that is. I know it is in the rules of many of these switchings inside the UK. But to the first reading, I don't think it is there. I don't think a department in the UK would be counted as a government funded one for that rule, if you're asking about that rule. Thank you very much, Patty. Thank you. Okay, what else update do I have? I'm trying to remember from my recollection. TLS appointments, yes, they have improved over a period of time. That is happening. Okay, Elizabeth, uh, will the new salary threshold of 25,000 be applicable to entry level band 3 NHS HCA? I have been with the employer for 5 months, currently in PSW, must apply for skilled visa. 25,000 be applicable for entry level band 3. Sorry, it is quite a technical one. I will not be able to answer. I have to check the rules properly and match the numbers, but I don't know what you mean by band 3. I think, let me try to answer to the best. Will the new salary threshold of 25,000 be applicable to entry level? I don't care. That's not. I have been with my employer for 5 months. Yes, that is not relevant. New salary threshold of 25,000. I'm not aware of any changes to the skilled worker visa as yet, but I'm not sure which changes you are referring to. Is that last year's April's? Other than that, there is no changes to the salary requirements. Sorry, I'm unable to answer that. Yeah, maybe speak to an immigration lawyer, book a consultation with us, and maybe we can discuss and calculate all the things for you. Okay, next update that I have is pre-settled, settled. I've covered. What did I cover? Spouse visa financial requirement. No update yet. Uh, yeah, we are still waiting for the whatever inputs were given to that MAC advisory committee. Harry Perry, what happens if FLR gets rejected? Can we file for an appeal? If you are put on immigration bail, usually that is what is happening. Yeah, watch my videos explaining those things. Yeah, FLRs are ruining everyone's life. Once, as soon as you applied for that, unless you vary that application before a decision is made, if it is refused, they will put you on immigration bail, especially whoever is trying to buy time with those. If FLR gets rejected, I think no, you don't get an appeal right. It's not a human rights application. No, you won't get an appeal right if it's a normal FRR, others. Okay, next update is, yeah, you'll be put on immigration bail and you may have to leave the UK. You won't be able to switch out into any other route from inside the UK if your FLR is rejected and you are put on immigration bail. So they are putting everyone on immigration bail. Recently, yeah, we've also seen a situation where sole rep extension was refused and the person was put on immigration bail. Quite new, but yeah. How long does it take for FLR to reach a decision? It depends how lucky you are. Anything between 3 to 6 months usually. That's what I would say. Uh, What else? But yeah, FLRs, I know they are picking up them very quickly. Even individuals where they didn't even attend appointments, I know many of them reported on the channel where they didn't attend the appointment. They were trying to delay that to that 42 days timeline of appointments. Even before the appointment, they have put them on immigration bail. So FLR is the worst area to get onto. Geeta, can you add more details about extensions such as low going rate and high going rate? Extensions, summarily, I can advise is if you're already on the skilled worker visa under the old rules, that is before April 2024, then the lower going rate applies and depends what formula has to be applied. So it depends on, for standard, let me just take the standard and explain. So you have to take the base rate is 29,000. Let's say when you applied before April 2024, the base rate was 26,200. So, but now for extensions 29,000 base rate will apply, not the 38,700. Okay, 29,000 is one number. Second, let's say your going rate is, let me take what example. Let's say your going rate is 28,000 for that particular job, the lower threshold. So 28,000 or 29,000, whichever is higher. So you should be paid at least 29,000. That's just an example I took. So minimum would be 29,000. Yeah, so you joined the area before 4th April and now you are extending. So that's what I explained. So 29,000 or the going rate, whichever is higher. That is the formula. Lower threshold going rate. Okay, I have about 5 minutes more. Let me cover whatever questions I can. Okay, time management. Amal, can I appeal if I get spouse visa rejected due to working 23 hours one time during student visa? Spouse visa. So, are you talking of a spouse visa of a skilled worker spouse or a British citizen or a settled person spouse? So, if it is you are married to a British citizen or a settled ILR holder, then yes, there will be an appeal right, and yeah, you can take it from there. Um, Yeah, you can. Even breach of immigration rules, I don't think it would be refused, yeah, to the best of my understanding, because breach of immigration rules will have to be ignored if you are a spouse of a British citizen or an ILR holder, number one. But yes, if you are a dependent of a skilled worker or any PBS visa holder, then yes, it can be refused. Yeah, speak to an immigration lawyer, book a consultation with me, and we can discuss if any of those apply to you. Abdul Kudus, on FLR, on FLR status, can we apply for a dependent visa husband from within UK? Husband within the UK. If the main applicant wife student is applying from India. Student applying from India, firstly, your wife should be on a course which allows dependent, which should be research based or a PhD. So make sure you check with the uni, number one. And switching inside UK from FLR, let me think, can I switch? If it depends what your previous permission was. If you had a valid permission, you may be able to switch because your previous permission applies till the time the FLR is pending. Yes, you can apply for variation of that leave, variation of that application. But if it is decided, they will put you on immigration bail. You'll have to leave the UK and apply from outside the UK. So summarily, or book a consultation with me. Links will be in the channel information or in this video also. I think somewhere it is there. Okay, so Harry Perry, a person claiming to be a lawyer, gave me advice. Bape, who is that? And I applied for fee waiver for FLR. Fee waiver for FLR, very interesting. The application got rejected, and the so-called lawyer told me to apply for it again. Interesting. I think your immigration situation may be, yeah, worsened. That's what I would say. Don't think you may even have a Section 3C leave if you back-to-back applied after fee waiver. Section 3C is protected only if you make the same application. I don't think you may even be legal in the UK. You may not have a Section 3C leave, to the best of my reading of the rules. The reason being you filed an FLR, and after that, within 10 days, I know of the refusal, you may have filed this FLR application. You filed a fee waiver, within 10 days of refusal of that, you applied for this one, FLR. But on the application, when you apply, you didn't file the application which you may have promised, which is the family route. I'm just talking to myself here. But yeah, you may not have Section 3C leave. Sorry, that may be opposition to the best of my understanding. Okay, maybe 2 more minutes. My son was refused by tribunal and then an upper court. I did not have a lawyer. When I mentioned in court, they gave me a due date, but now I have received a letter stating later I got to know that it is not possible. I wrote it to my FLR that, okay, so Harry Perry. Okay, Abdul, I didn't get your full question. that my case has been sent back to the tribunal. Yeah, it is normal. Cases being sent back to normal. Sometimes it is reconsideration and all. That is normal. That's not an issue. Harry Perry, last one I will take. Okay. Later I got to know that it is not possible. I wrote it in my FLR that I was scammed, and hence I know I'm applying for FLR. I did this in 14 days. Yeah, even if I know, even if in 14 days, whatever you applied, it's not 14 days. If a favor is refused, you have 10 days to apply. So, but to the best of my understanding, whatever you told me, you don't have Section 3C leave, and your FLR is definitely bound to be refused. I'm giving you bad news, but I will tell you the truth rather than other lawyers making money off you. So, yeah, you can book a consultation and discuss if you want to and pay for it. But summarily, to help you out, I don't think you may have status in the UK. Even that FLR would be rejected, most likely. Okay. Yeah, Abdul Rahman, yeah, sending back to the tribunal case, that is normal, that's fine. Okay, so I will end this live. Thank you very much, anyone who joined.